So let's start that.
Recording in public.
Okay, everybody, hello and welcome to the Birch Law presentation of how to avoid probate court when you pass away. What is probate court? Why do I want to avoid it? Do I want to avoid it? What does it all mean? I'm Lori Birch. I'm the owner and founding attorney of Birch Law. We have been helping people with wills, trusts, powers of attorney, and probate going on 17 years. It is now much bigger than me. We have other attorneys and other amazing support staff that hopefully all of you will get a chance to interact with if you haven't already. I'm going to have some slides here and be asking for some interaction, and then we'll definitely have time for questions and answers. And here's how I want to do this. I want to at least get some of this basic fundamental information out there to you, but I don't want you to lose track of your questions. So put your questions in the chat as you think of them. And I promise you at the end of this, I will go back and I will answer each and every question. You can, within reason, right? I mean, I don't know what you're going to ask. You want to know my favorite color, then you can ask that. But if you'll put questions into the chat, we can do that. I'll probably be posting some things if I'm referring to like websites or other resources in the chat as well. And yeah, so if you are watching this on Facebook, you are going to have to make sure that you register through the registration link, or else I'm not going to see you. And I am not obligating anybody else with the team at Birch Law to be a part of this. So I'm going to be multitasking as far as pushing the slides and letting people in the waiting rooms and all of that. So bear with me, be patient. All right. So here's more contact information you see on the screen. Our phone number, which you can call or text, how to email us, our website. And of course, if you're watching this on Facebook or you're a Facebook person, like us on Facebook. Why not? You'll get more information than you probably can handle that way. All right, so moving right along. So first, disclaimer time. This is just some general broad information. This is not meant to create an attorney-client relationship. Whenever we talk about these things, and again, I will answer questions, but you need to remember that the best advice is the advice that's catered to you in your particular circumstances. So a lot of this will be generalities. This is specific to Texas. And if you need to have more questions answered when it comes to your particular set of circumstances, then you're going to want to make sure that you schedule a consultation. All right, now that that fun is over with, what will you discover today? Well, we are going to talk about what happens without a will or a trust or any sort of estate plan, what the probate process is. You may hear about this. Some people call it probation. It's not like that, although it might be just as bad. How to avoid unnecessary court processes, and what you can do now to get the right plan in place. Because, knowledge without action is not knowing. Right. So you really need to make sure that you are taking action. And so at the end of this, I hope that we will have inspired you to take some action and not kick this down the road. Because as a estate planning and probate firm, I can tell you every day we get calls from people who always meant to get around to it. And now it is too late and you've left a mess. And that's not what we want to see for you. And then finally, we're going to talk about something near and dear to our hearts. It's part of a new program that we've launched called the CYA plan, the Cover Your Assets plan. So we're going to talk a little bit about that. So let's dive right in. And the first thing that I want to hit you with is something that not a lot of people seem to be aware of, and that is a will has to go through probate court to be valid. What? Yes, it is true. We've had so many people that will call us and say, my mom's passed away, she has a will, and I'm the executor. We have to tell them it's not a will until a judge says it is, and you're not the executor until a judge says you can be. Now, a will makes things a lot easier and more efficient, and the biggest, most important part of a will is your wishes are being expressed rather than the state of Texas making all those decisions for you, some of which we are going to talk about. But a will does, in fact, have to be approved by a probate court. Now, in the past, probate has been fairly simple in Texas by comparison, okay? That's an important distinction with a will, because we have a process called an independent administration where an executor can act independently and there's not a lot of court oversight and things that can cause more delays and expenses. That has changed greatly in the last couple of years. There has been continued delays. There has been a lot of extra things that courts are requesting and asking. So probate has become a little bit more cumbersome in Texas. We're going to talk about more specific, like what are time delays, what are some potential costs. So we're definitely going to cover that. But I will always like to start with this because it's a very common misperception, understandably, that people have, is that a will alone is not going to prevent some court oversight and governance when it comes to passing away. So look, there's a lot of stuff on your screen right now. Here's some good news. I'm not going to go through all this with you. I just want people in general to start getting an idea of concepts of what is a probate court process. Well, there's many different types of probate. So when you have a will and it has all the requirements and formalities, what does that mean? Well, it means don't do it on the internet, because most of the time those aren't valid, or most of the times there's deficiencies with how it was signed. And so we have extra hoops to jump through. But in general, there is where you get, the executor gets appointed, and they get appointed, and this is what I was referring to a moment ago, as an independent executor, meaning they get to act independently of the court, and they get what's called letters testamentary. If any of you have gone through this process, then you might be familiar with that terminology, sometimes called letters of administration, but letters testamentary is the official document that says you're the executor. So you take it to the bank, they let you into the account, you can sell a house, I mean, all of those different things. Sometimes you have to do what's called a dependent administration, which means the will did not require or allow for the executor to act independently. So that will take more time, more oversight. Whatever, if the house gets sold, the court has to approve it. Getting into the accounts, the court has to oversee it, has a lot more reporting. Then there's another thing, and again, this isn't training you all on what probate is in depth, but there's also something called a muniment of title, which is using a will, but it's like the legal probate equivalent of it is what it is. So we don't typically like to use the muniment of title at Birch Law, and we think it's not advisable because there's a lot of missteps and it really doesn't save a lot of time and money at all in the end. But sometimes you have to. Sometimes the will doesn't name an executor, or sometimes it's been more than 4 years since someone passed away. And so, or in one of my cases, all the executors were convicted felons, and so they couldn't serve as executor. True story. And so we have to use this muniment of title, which can work in order to be able to sell a house or get into an account, but it's not as commonly accepted with a lot of financial institutions. So it's not something you want to rely on, but it's something that you can. Now, what happens without, well, let me back up, because I promised like potential costs and time, and there's another slide later where we'll talk about this a little bit more. But average costs here of probate with a will, particularly letters testamentary, independent administration, assuming that there's no other deficiencies with the will, no other challenges, no other requirements from the court, that's still going to cost about $2,500 to $3,000 in total, at least, to probate the will. Now, that's still dirt cheap compared to no will, because we're about to get to that. But it also takes several months. One, it can take some time to get into the court. We'll talk more about that later. And then there's still some expenses obviously involved with that. Now, without a will, there's a couple of options that you have, but this is where we've really seen a big trend in the last couple of years, where either it's title companies when it comes to a home, or it's courts or financial institutions. A lot of these alternatives that you see here, like the small estate affidavit or affidavits of heirship, are not being accepted as much. And those are abbreviated ways of things that we try to do. So small estate affidavit means there's no will. And it's important for people to have some understanding of this, because I cannot tell you how often we'll have somebody who's passed away and the bank will tell them, oh, you can just do a small estate affidavit, but there's a will, or there's multiple accounts and it adds up to over the $75,000 threshold. So that's not accurate at all. But a small estate affidavit is when, for the most part, there's not any real estate to deal with. There are some exceptions to this, but I'm trying to keep this simple. And the assets are under $75,000, not including any sort of real estate again. Now, if there are debts that exceed how much it is, you cannot use the small estate affidavit. For example, if there's only $20,000 in a bank account, if there's $30,000 worth of debt, you can't use the small estate affidavit. An affidavit of heirship is where people who knew the person who passed away are willing to sign a sworn statement that they knew them, knew their family history, knew who they were married to, knew what their assets were for the most part. And sometimes title companies will accept that in lieu of anything. But here's the important takeaway before I really get to this determination of heirship, is that even if you can do these other abbreviated versions, it's only going to go according to what the state of Texas says, which can be kind of surprising. So listen to this. A couple things that kind of surprise people is, one, when you have blended families, which is very common. So if you've got stepkids and you don't have a will, which remember, that's what we're talking about here right now, then the court or the state of Texas actually says that the person who passed away, their part of the community property will actually go to those children that are outside the marriage and not to their spouse, even if they bought the home together. So the point being is there's a lot of things that may surprise you about the default laws. So the court's going to determine, according to state law, how assets or money is going to be distributed. And it's not always the way that you think. The court's going to determine who is going to be in charge of overseeing paying off expenses, distributing property, all of that. It's completely out of your control. You don't get to choose it whatsoever. So with any of these things without a will, it's only going to default to who the heirs are, meaning who Texas says is in the lineup of who should inherit property or assets. So the determination of heirship is as full-blown of a probate process as you can get. And really 99% of the time, we're in the position of telling people you're better off not trying to do a small estate affidavit, not trying to do an affidavit of heirship, because we're running into so many issues with that, and just biting the bullet and doing a determination of heirship. And I'm not going to get into all the details of this, but just to give you an idea, what that looks like is you have to apply to the court to have an attorney ad litem appointed by the court to research who the heirs are, and then report to the court, these are the people, and this is who should inherit what percent of what. And then you try and get all the heirs, hopefully, to agree upon who can serve in the executor role. Technically called an administrator, but that's the case. So determinations of heirship, they can take months, if not years, to get through the full process. And, you can average around $7,000 to $9,000 to have to go through that experience. So when we talk about, when you talk about the cost of having a will or even avoiding probate, a lot of times I tell people, well, cost now or cost later, because it can be surprising. And you may be thinking, well, what's entailed with all that? It could just be a house. It could just be a bank account. It can be a life insurance policy that doesn't have a named beneficiary. All of those things can lead us right down this path. And the one thing on here that I haven't mentioned is there is an affidavit of heirship for motor vehicles. I'm not going to get into the details unless someone has a question about that, but that is something that you don't even need an attorney to prepare for you, but can be a simple way to transfer a car title. But again, it's just going to go to the heirs that is determined by the state of Texas, not to anyone you are choosing. All right, so what's next? Let's talk about this. So when we talk about real estate, real property, there's a lot of things to keep in mind. So one, we are a community property state. There are not many community property states. So this is a little bit unusual, but there's 9 of them and Texas is one of them. And so what does that mean? Well, for lack of a better explanation, anything you had going into a marriage is your separate property. Anything you acquire during the marriage is community property, regardless of whose name it's in. So if you get married, but you then go buy a home that's just in your name, technically that'd be community property. There's some exceptions there, but in general, that's the way to think about it. Some exceptions are inheritance during marriage or gifts during marriage. But for the most part, once you say your I do's, everything is becoming community property. And so this is what I was talking about before. If you have children from a previous marriage, if you don't have a will or a trust or any sort of estate plan, those kids will actually get your half of the community property, not your spouse, even if you bought the home together, which kind of leads into this next thing. So this joint tenancy with rights of survivorship in Texas, this is important to listen to. It doesn't exist. We don't have it. So in other states, in many other states, if a couple buys a house together and both names are on the title, If one of them passes away, it automatically goes to the surviving spouse. No, Texas does not have that. Now, there are ways to create that. One, a will can make sure it goes, even though it has to go through probate. Two, this transfer on death deed is something that we sometimes use, where you can actually put together a deed that says, upon my death, I want my property to go here. Sometimes you may have heard survivorship agreements, but the point is it's a subsequent deed or filing that gets recorded in the county record. And you can do those, and that will avoid probate and give you this kind of automatic survivorship thing. However, that's not necessarily going to take care of any other assets. So bank accounts, life insurance, any of those things, that's not going to be anything that will avoid any sort of probate court process. But sometimes they can be really good tools. I'm going to pause here for a second, just as a reminder for those watching on Facebook. I am going to be taking questions, but you need to register. The registration link is in the chat, and I'll let you in. But for those of you who are a part of this, if you have questions that are coming up, I'm going to answer them. If you want to go ahead and put them in the chat, put them in the chat, because I will get to them. I just want to get through some of this fundamental information. So let's talk about something else, what's called non-probate assets. So all that means is that there are certain types of financial accounts that you can pre-designate who you want that to go to, and it won't be subject to probate court. It won't even be subject to wills or anything like that. So it has to do with things that you typically name beneficiaries on. So think of life insurance, retirement, IRAs, annuities. If you have a financial advisor, you're usually, whether you realize it or not, or even an HR department, you're signing who you want the beneficiary to be. This is going to go, that particular asset will go to whom you name. Now, if you don't have anybody, and we get this sometimes where, maybe a spouse passed away and the survivor never went to update their beneficiary. So if there is no living beneficiary designated, then this is actually would fall into your estate. So if there's no will, then it's according to the heirship stuff that we just went through. If there is a will, it would default to the will, and so forth. Some things that you don't want to do, though, and when you're naming beneficiary designations, is you should not be naming minor children. And this is a big thing because we at Birch Law, the majority of our clients, in fact, have young children. And so if you name a young child, then that can't be distributed to them. And so a court's going to have to get involved. Money goes in the court registry, and then a court determines who can oversee it. And then at age 18, it's just given to them. So you're far better off putting together a will that has some sort of trust mechanism, or putting together a trust or something. And then you're going to want to designate that beneficiary to coordinate with that, which is all something that a qualified firm should be helping you with. That's something, in case it's a question on your mind, like, should I be doing this on my own, or how do I determine, the best type of firm to use? Definitely make that one of your questions that you ask is, will you help guide me on how to designate beneficiaries on life insurance, retirement, and what we're going to see in the next slide, even bank accounts. But typically, what I'm referring to here is different types of designations you can put on these assets. As you can name a person, an adult person. You can name your estate, which just means it'll go according to your will, or if you don't have a will, default laws of Texas, or you can name a trust, a living or a testamentary trust. We're going to get a little bit more into this in a second. A living trust, brace yourselves, is a trust that exists right now while you're alive. A testamentary trust is the opposite. It means it's a trust that would get created upon your death. So if I have young children and I say, hey, if I check out and they're under, let's say, an age I choose, like 25, then don't give them the money, let it go into a trust. This is who I appoint as my trustee to make sure they're overseeing that for them. All right. So while we're still talking about these non-probate assets, so again, these are types of assets that you can put designations on that could potentially avoid any sort of probate court process, is let's talk a little bit about bank accounts. So not everybody necessarily sets up bank accounts in any sort of particular way, but you can. So unlike what we were talking about with real estate in Texas, where there's not this right as for survivorship where it automatically goes to a joint owner, typically banks, and you may not even realize you're signing this when you're creating your accounts, but actually will allow those assets to go directly to the other person. So if you have an account with your spouse, or I see sometimes a lot of parents will set these up with their adult children, then if one passes away, then that, free of probate, free of being frozen or anything, it'll go to the other person. That doesn't mean you want to do this. If I haven't made that clear, I'm not saying any of this is stuff that you necessarily want to do or should do. It's very specific to your circumstances, because there are many instances where you don't want that setup to happen. But again, that's going to be very specific to what you're looking to do and what your plans are, which is why you should work with a qualified firm to be doing this, because you're not going to know how this all plays out if you're trying to do it on your own, or if you're trying to get the cheapest, firm in town. They're just going to generate paperwork for you. They're not really going to guide you or give you advice, because you absolutely get what you pay for when it comes to this really critical planning here. Now you can also do what's called TODs or PODs, transfer on death, pay on death. That's doesn't have any effect while you're alive, but when you pass away, it can be something where it, like a beneficiary designation we just talked about, where it can go directly to someone. May or may not be something that you really want to incorporate in your plan. Sometimes it's a good thing to do, sometimes it's not. The account will still get frozen upon your death, and there's always going to be extra steps to get those accounts open. But it can be, in some cases, a seamless way to at least get some money in the hands of someone before there's a court process. And then something we're going to talk about in the next slide is a revocable living trust. And, I'm not here to say that everybody should have a living trust, but I do want to say that this is a really great option if it fits for you. It sounds super fancy, and a lot of people think they have to have a top hat and a monocle to need something like this. That is utterly not true. It completely is focused around, or for the most part, focused around avoiding any sort of court process. So while you can do these piecemeal things, we talked about the transfer on death deed for a home, and then you can do beneficiaries of life insurance, and then you can do right of survivorship or pay on deaths on bank accounts, very piecemeal. A revocable living trust, as we'll talk about more in a second, is a really holistic one thing that you can do, and then you can connect any of your assets now in the future to it, so that that you're really covering everything. And so the last thing I want to say before we move on here is that for a lot of people, the majority of their money and assets are going to consist of these things. And so it's very important not just to think that you need a will or some legal document, but you really do need to be getting the guidance and advice from qualified professionals on how to set these things up. Because, we see all the time people that'll go on the internet and they'll fill out a will and everything, and then they have everything is tied up in bank accounts and beneficiaries, and it's not what they wanted or intended at all. So a lot of trouble you can get yourselves into. So I've got a few more things to go through here. Again, I'm trying to do this pretty quickly because I do want to allow time for questions. But we're going to move on to a little bit more information about that infamous revocable living trust. So there are a few things here, and I always mean to update this presentation so that everything appears at once, but I haven't done it yet. So here it is. So a revocable living trust is basically a document that you can create. Think of it as like a bucket. And if you're married, you can do a joint one. You can also do separate, but very common to do a joint one. If you're single, you can do one. You make yourself the trustee of it. And then more about this in a moment, but then you connect the assets to it. So you can deed your home into it. You can make beneficiaries there, bank accounts, cards. You can connect all your assets to this trust. You can still manage everything the way you do now. There's no separate tax ID or tax return. You want to sell your house, buy a new house, close an account, open an account. You can do all of that. The benefits is, unlike a will, when you pass away, if everything's connected to this trust, there's no probate court. So it speeds things up tremendously. It reduces any of those expenses, if not completely eliminates any probate expenses. And then one thing you'll see listed on here is that it's completely private because it's not a public record, whereas a will is a public record. So there's an extra layer of privacy when it comes to a will, and less oversight on behalf of a court. And so again, it saves time, saves on the probate fees, protects your privacy. If you have out-of-state property, with a will or without a will, basically without a trust, you have to go through a probate process in each and every state where you have real estate property. With a trust, you have the ability typically to connect all the property to the trust, so that if I've got a home in California and a home in New Mexico and I live in Texas, then I can connect those all to my trust. So if I pass away, my family doesn't have to go through any probate, not only in Texas, but California, New Mexico. It circumvents all of that. The other thing that we haven't talked a whole lot about is that, sometimes if you start to lose your capacity, Alzheimer's, dementia, so forth, sometimes there has to be a court-imposed guardian to step in. A living trust actually has the added option of helping prevent a court-appointed guardian, because you can actually make a provision in there that says, look, if I start to lose my faculties, it's still all my property, but here's the next trustee that can step in instead of me. So it can help, again, avoid a lot of expense in court interference, which is what most people want to avoid. But sometimes some people are like, no, I think I trust the court more than my family. So, hey, so some considerations, not disadvantages. I want to be really clear. Considerations. Trust costs more to set up than setting up a will. Now, quite often we get asked, look, I just want this to be as easy and as inexpensive as possible. And so our question is, now or later, because you can't get it both ways. So it absolutely will save money if you do the trust, but it is more upfront expense. So, if you want to save the money down the road for your family and loved ones of not having to go through a probate process, and like I said, even a will goes through probate, then you're definitely going to be saving money and saving time. However, if you just don't want to pay the extra money to do a trust right now, just know that you get a nice foundation of a will in place, but there will be additional expenses later. So a living trust, while some people will say, gosh, that's a lot more money, in the end, you're absolutely, if you're into ROI, return on investment, it will save money every single time if, the next consideration, you do the work of it. One of the benefits of making this so easy is there's some things to do, and that is the connecting the assets to the trust, which a good firm, or in our case, a great firm, is going to help you with and guide you and tell you how to do it. But there's just some things that you're going to have to do. Like nobody else but you can go and change your bank account. Nobody but you is going to know that you're buying a new house and you need to connect that to the trust. So on here, it says you still need a will with a trust because it's just in case. I mean, ultimately, you hope you never have to use a will when you have a living trust, but it is in case you do forget, whether it's that bank account or that one thing. It doesn't prevent them having to go to court, but it will ensure that everything's distributed according to your wishes. And by and large, a living trust will say the exact step a will does. This is how I want all my money distributed. This is how I want my assets distributed. And this is who I want to be in charge of doing that. But it is a nice mechanism for those who are going to do the work of it to really, really make things easier, faster, and less expensive and more private when you pass away. We're getting close to wrapping up here. So again, if you've got questions, be thinking of those. I'll be happy to answer that. Or maybe I'm just so darn thorough, nobody's going to have any questions, and that's fine too. But just a little bit more on the living trust, just to give you an idea. These are the type of things that when we say move into the trust, I'm using very non-legal terms because what you'll want to work with your attorney on is how to connect assets. And it's really going to depend on the type of asset. So, insurance and life insurance and retirement, it's typically beneficiaries. Banking accounts, it's typically changing it into the name. So it's actually the owner is the trust. Not always, but that's kind of how we do it. With businesses and cars, sometimes we just do an assignment where you sign something with your trust that says I'm assigning those assets. Real estate, you can do deeds, you can do the transfer and death deeds, you can do things called ladybird deeds, all of these different things. But it will be important to start connecting things to the trust, which is why I picked this picture, because I thought it looked like you're connecting things. So the one of the big things I want to hit on, so I'm not going to go through each of these, but I just want it to be on the page because not all firms I see are as thorough as a firm like ours. And so I want you to be familiar with some of the actual types of documents you should have. Now you'll notice revocable living trust isn't on here because I'm not going to say it's a one size fits all. If you were asking me, what is the foundational plan? So maybe it shouldn't be recommended plan. Maybe it should be more foundational plan. I'll change that for the next time. But you definitely want to at least have a will. You want to have a directive to physicians, which in Texas is our living will saying you do or don't want your life artificially prolonged. Medical power of attorney. You can make medical decisions for you if you can't make them for yourself. HIPAA release, making sure that whomever you want to make medical decisions will have access to medical information to do that. Financial power of attorney. You can step in and pay bills and contact banks if you are hospitalized, disabled, or in an accident. If you do ever have to have a guardian appointed for you, you can actually pre-designate who the court can pick. One of my favorite documents, mainly just because the title is so fun, appointment of agent to control disposition of remains. Probably pretty descriptive, but if you're still wondering, I'll elaborate. You're designating who can oversee any type of funeral, burial arrangements and so forth. If you want to be an organ donor. And then I told you that, a lot of our clients have young children. There's also this designation of healthcare agent for children. It's like a medical power of attorney, except they're under 18. They can't do it themselves. Because when you establish a guardian for a child in your will, for example, that's only if you pass away. But if you're traveling or disabled or hospitalized and there needs to be an emergency medical decision made for your child, nobody has automatic rights to be able to go in and do that but the parents. So you can actually create a document. And so, for example, I've got two stepkids. So I actually have one of these because I take care of them. If I need to go and make emergency medical decisions, their two legal parents want to make sure that I can do that. So that's a good document to have. So good. I see a question there. If you have questions, we're getting towards the end here. Put them in the chat. I'll answer anything and everything that I can. You can always reach out to, if you see, the website. Our website is on every single slide. You can go there. There's a contact us. To ask questions and find out more information here. So let's talk a little bit about costs, because look, even though we know the value and what you're avoiding here, sometimes we do need to truly help people understand why it's worth spending money to save so much more money and time in the end. So I'm not going to go through each of these. If anybody wants this, you can request it from us because we have this in a PDF form. But here are a lot of things that if you have no planning, you don't get to pick guardian of your kids, trustee of your kids, who receive assets, someone to carry out your wishes, public record, avoid probate court oversight, remarriage protection, plan for incapacity, ensure home goes to spouse automatically. So, by doing nothing, you really are looking at, even if it's just a home, even if it's just a few bank accounts, this can still be the process. This is just the cost. We're not even factoring in the emotional cost of grief or the time frame, but that can easily be over $7,000 to go through this process. If you do a will as a foundation, you definitely get to do all of these things. You're not going to avoid, it's going to be a public record. There will be court oversight. I can really get to the nitty gritty of why these things mean what they mean, but that's for if you have more specific questions. And then probate's probably going to be around $3,000, give or take. Now, if you do the will with the trust, like we were talking about, and you properly fund it, meaning connect the assets, then you can have all of these things and there should be zero probate fees. So again, when you're looking at like price tags of what does it take to do this correctly, and I mean that, like this isn't the online stuff, it's not the cheapest firm in town, you're not going to get these things. This is kind of what you should be looking at as a potential cost. Now, keep in mind, I am putting fees in here based off of couples. So if you're an individual, it can be less than this. And it's also basing it off of including all those other documents in that last slide. So like all of these documents, sometimes people will just end up getting a will. We don't recommend that, but these fees are based off of a full package. So you could be looking around $1,500 to do a full plan with a will, even as a couple. You may be looking at closer to $2,750 if you're doing the full plan as a couple. Now, these fees can be less depending on certain circumstances, and they can be more if you've got more specialized circumstances. But just to give you an idea, because people are like, I just want some sort of range or idea. Well, there's the idea. So, the question is, would you spend this, to save on that, to save, $4,000 or more? Would you spend that? would you spend this to save, 7,000 or 3,000? And then again, there's not the emotional or grief time. So just an idea there. So if you got questions, put them in the chat. I'm going to get to those. Couple more things. Want to talk to you about something, and please note the website here. I'm actually going to put it in the chat too, so you all can have a link. This is something that I could do a whole presentation on, and I do, but I just want to allude to it now because the CYA, the Cover Your Assets plan, is actually a new exclusive plan that we have at First Law. There's no other firm that has this. This is for those who already have the will or trust in place, whether it's through our firm or through a different firm, or even if you've done the online stuff. So this is if you want some additional help. And what the CYA Cover Your Assets plan is, it's a 3-year plan. It's an add-on, so it's additional cost, but it's not required to get anything in place. And it's where we'll do an overview of how to set up your accounts, your property and beneficiaries, and we'll work with you to make sure that they coordinate with your plan. If we need to talk to bankers, financial advisors, whomever we need to do to make sure that we can get this set up for you. We also give you what's called the CYA organizer, and then we will help make sure that you actually get this information together of usernames, passwords, where do you keep important paperwork, who are the mortgage companies, streaming companies, utilities, how do you get into your iPhone lock screen or your smart screen? I mean, all these different things that when you see the question there, that if you died today, would your family know where to start and know what to do? And so that's the question to ask, because even if you do have an estate plan, wills or trusts, the answer to that, I can tell you right now, I know is no, because they don't know how bank accounts are set up. They don't know where to find that information. So this is some additional services that we provide. That is 3 years that we're going to work with you to get your particular goals set up. And then lastly, and again, go to CYAlaw.com and you can see the full list of benefits. It's like 15 different benefits that you get. But the last one that I want to mention specifically is at your year anniversary, we're going to send you a checklist of certain life events, and then we're going to analyze that and see if there needs to be any changes or updates. So all of that is part of this, this accountability and maintenance plan called the CYA plan. You can always get a will and trust in place and decide later to add the CYA plan. I mean, typically what happens is, after a month or two after signing your paperwork and everything sounded good, like doing the CYA organizer with passwords and usernames and making sure bank accounts are set up the right way, you find that life just happens and you haven't done any of it. And then we reach out and say, how is that going? Would you like any additional assistance from us? And then quite often people are like, yeah, I definitely see the value in getting that help. So the CYA plan is an add-on plan to the overall estate plan. It's a complement to it. And so just to wrap up here before I start asking any questions, or I'm going to ask you all questions, answering any questions right now, just to, try and get people motivated, because if you put this off, it's just not going to get done. And it's a really big hassle. So if you text CYA to our phone number, 972-385-0558, we can set up a complimentary discovery call that's where you'll talk to one of our dedicated client concierges, where they can go through some more basic information. And if you decide you want to set up an actual strategy session with one of our attorneys, then we can do that. And if you do that, I'm trying to think of incentives, because people, you need to get this done. Like, people will be like, oh, we'll get around to it. We'll put this off. And it's like, what are you waiting for? Sometimes I'll use the example of, it's possible, yeah, that you might not need to have a will or trust or estate plan this year or next year or anything like that. It's also likely that you're not going to get in a car accident this week. And so I ask you, would you go this next week without putting your child in a car seat or buckling your own seatbelt? Now, some people are like, yeah, I'll take that bet. And that's fine. Maybe you're not a good candidate to have an estate plan now. But for the majority of people that we talk to, they would not even fathom driving down the street without putting their kid in a car seat. So why the heck would you wait one more day to get this vital plan together. Because no matter what I can tell you is, while you may not ever get in a car accident, and I hope that for you, you're going to check out at some point. And if that's a reality that I'm going to have to bring to you, then I will accept that responsibility, because we get far too many calls where someone had the best of intentions to get to it and they didn't, or they started the process, or they felt like, well, let me get my tax return and I'll do it then, or let me, I might get transferred, or what if we have more kids, or this or that, and all these reasons or excuses, if you want to look at it, to put this off. You will never, ever regret getting this in place and having it done. And hey, maybe you got to tweak it once or twice. There might be additional fees to do that, but the peace of mind and the protection for your family and loved ones is just exponential. So we're very passionate about getting this done here. And so if it is something that you're interested in, the offer that I can make is on the CYA plan. I didn't talk about the fees associated with that. You can reach out to us when we talk about it, but you would get, you would qualify for a $250 discount between now and December 31st. If you just text CYA to that phone number, and then we'll follow up with you, and that'll be a credit that you'll have with our firm if you decide that you also want to do the CYA plan, or if you only want to do the CYA plan, like I said. So with that, I want to thank you for tuning in. If there are questions, I think I saw, let's see, consultation was it? So yes, so hopefully, Angela, I explained that, and I saw your other message. So presuming that you have, we should have your email address. If we don't have your phone number, I don't know if you'd mind putting that in the direct message to me that nobody else will see, and we can follow up with you and get that information on how to get started and to answer some of your questions. So definitely be happy to do that. Are there any other questions that anybody has for me, or do we actually let me stop sharing so I can see everybody better? What are the implications to rental properties? Oh, great question, Irene. So, that's a little nuanced in the sense that, actually, let me make a note for Angela so I don't forget here. Hang on. Okay. So one, you're kind of opening a can of worms there, because we have a lot of people who have rental properties. And so one thing that is not your question, but lawyers are great at answering questions you didn't ask. And so I am no exception to that. But rental properties are something that you might also want to consider setting up like an LLC or some sort of protected entity, because if you've got renters, then it opens you up to liability if you get sued, or someone on the property, and they can go after all your assets. So that we also handle business law. So if you do have rental properties, we'd love to help advise you on some of the implications of possibly setting up those type of things. That's in addition to the whole living trust thing, or I'm sorry, the whole estate plan thing. As far as one bought with inheritance, one bought, it kind of depends what exactly you're asking, because with divorce, which is, I know, not your question, that's where sometimes a lot of, okay, it's a rental property, one was bought with inheritance, this one's before marriage, so it's my separate property. If with a divorce, then that's where you track that, trace that, kind of negotiate it. When it comes to the estate plan, it's really going to depend what you want to do with those things. I mean, if you want those to go to a spouse anyway, then we can set it up that way. If you're wanting to set up things where you want to allocate certain property to go, maybe not to your spouse, but to kids or something like that, those are all things that you can set up. I mean, we can do that through wills, we can do that through trusts. Sometimes, depending on the circumstances, we need to do, if you don't have a premarital agreement, sometimes we need to do the opposite of that, which is a postmarital agreement, just to make sure that assets truly are separate. Because one thing that's a little nuanced, but increase in value or income off separate property can become community property. So if you've got a property, let's say a home that's worth $200,000, that's yours before marriage, and then upon death or divorce, it's $300,000. And technically that $100,000 could be community property. So you can see where this gets really, really sticky. The good news is there's a lot of solutions to deciding, the first thing is deciding what result you want, and then getting the guidance on how to get to that result. And if you don't have a pre or post marital agreement, it can be a little trickier, meaning we've got to look at what some of those other kind of community property laws can be at work. And so sometimes the advice is, oh, you really should do a post-marital agreement and we can do this, but that's all things that a qualified firm should be able to work through, because it is somewhat complicated. There's a follow-up question on property acquired during the first marriage. Yeah. So if it was during the first marriage, then hopefully, and this doesn't always happen, so I do mean hopefully, that the divorce decree settled all of that. So that really should be a clean, separate property item. But a lot of that is just kind of it depends. And it kind of, the approach that we take is what's the end result or goal that you have, and then we build from that. Okay, I've got another question here that was sent just to me. I'm going to assume LVT means living trust, especially since you say California, and those are very popular there, because probate's really, really messy there. So if you have a trust or any paperwork that's set up in a different state, but you now are a Texas resident, we definitely can look at that, make changes. I mean, it usually from a fee standpoint, it's hard to tell you, because if we do need to make changes, it's kind of the same fees. It's like, you're not a current client of ours. We didn't do these original documents. So it's the same degree of work and advice that goes into updating things. So it's almost, you're kind of starting from scratch here, but again, it depends. It might be that your the language in there is fine as is, and there's only some other tweaks and all of that. But to get a real, to really understand what the process and expense could be, that's where I say text the CYA I'll go ahead and put this back in the chat since I'm not sharing anymore. You can text CYA to 972-385-0558, and then we'll reach out to you and help answer some of those preliminary questions. And if you decide that that we might be a good fit for you, then the client concierge will tell you how you can meet with one of the attorneys, myself included. Trying to see if I missed anything. So we're going to wrap up here soon, but if there are other questions, I'm looking in the chat here. And anybody who registered for this, you will get a recording. Probably will go out tomorrow, but we'll get a recording. How long does the process take? Excellent question. So for us to do, if we're not talking about the CYA plan, because again, that's an ongoing 3-year supplemental accountability plan, but to get your will, powers of attorney, or trust in place, we try to streamline this as much as possible. We really, really try to build in as few barriers as possible. So it's really like 3 steps. The first step is, once you've decided that, you've met with us, you want to move forward on this, then that's the first step, is just, talking about what you want to do, making some decisions. The next step is that we would draft everything, usually have all of that done within about 2 weeks. We try to go really fast so that you have something to review, and then you've got to review it. For people who don't necessarily want to review all the legalese and everything, then we can send summaries for you, but basically to make sure you're comfortable with your decisions. And then once we work through that, then you come in to sign. So that's step 3. Typically, the turnaround time is about 4 to 6 weeks. This time of year, we got a lot of people who kind of drag their feet throughout the year. So they're like trying to scramble to come in. And then because I'm not Scrooge, I do like to allow people to take some time off to be with their families and loved ones during the holidays. So it could be a little bit harder sometimes. But we also will really try to make a lot of accommodations if we've got like a major surgery or something coming up. But we like to have, about a 4 to 6 week lead time, if not maybe about 2 month lead time. But we have people who get it done more quickly. We definitely have emergency situations that we can expedite if we're able to. Sometimes there are expedite fees, but we work with you to see what we can pull off. And then if you do the living trust, though, keep in mind that you don't start, going to the bank or changing beneficiary designations until after it's signed. But the point is getting it in place, and then you can take whatever time you want. I like to see people have everything connected to their trust at least within a couple months after signing their trust. but a lot of people don't do it, which is one of the reasons the CYA Cover Your Assets plan was born, is that we can help nudge you along and be an accountability partner and actually reach out to financial planners and banks and everything like that. So that's about the, give you some baseline of ideas and process. Appreciate the question. All right. Well, I appreciate everybody's attendance. I'll see, I'm going to pause for a split second to see if there's other questions here. Thank you for that. Great. So whether you attended or not, you're going to get a recording of this. We tell people if you don't have a will, the state of Texas has one for you. Keep that to heart. But again, the whole point of this particular presentation was going even a step further. And so we're really passionate about trying to make sure that everything is as seamless and as easy for your family as possible. There's a lot of tools and resources, and there's a lot of value to it. And so our goal really is to help you understand what that value is and to try and really inspire you to take action, because every day is a day closer to this happening. And we realize this is depressing and not fun to think about. But it really is part of your story and your legacy and what kind of care you're showing to your family and loved ones, to not leave all of this to chance and up in the air. We see families torn apart over the simplest of things. I mean, if you would believe that I've had 2 different instances of people fighting over ashes. So if you think this is just about money and stuff, it's not. This is really an act of love for your family and loved ones, and really for yourself, because you're going to be writing the final chapter of your story. So far better to make it a good one, one that you have made things as easy and as seamless as possible. So reach out to Birch Law. We've got a full team. It's not just Lori Birch. I got a full team that is really looking to help you and assist you. And please get this. If you don't come to us, please get it done somewhere and remember us as a resource. And with that, I will bid you all a good night.